I tend to talk fast, so if I'm going too fast, just be like, slow down, slow down, slow down. I'm going to keep it very informal. I do have a presentation, a PowerPoint presentation, and I will step through it as we go along. But if you have a question at any point, please just, raise your hand and just ask me a question. And I certainly will take questions at the end. I want to thank you guys for allowing me to be here, to present to you, to talk with you, to answer any questions you may have. Again, thank you, Ms. Lewis. Again, I'm an attorney, Meredith Hammer, and I'm an attorney, as she said, has been practicing law for over 20 years. I sometimes can't believe it. Seems like just yesterday. But I do specialize in the areas of probate and real estate and trust and estates planning and contract law. So like the slide says, so I've done all those things, I have a lot of experience, especially dealing with, probate. And I'm originally from Indianapolis, Indiana. So I'm licensed there. And I still have clients in Indiana, and Illinois. Obviously, I'm licensed in Illinois. There are some minor differences in some of the laws, but not terribly much difference. Let me step through this. So I think this first slide has my guy, Prince. Why am I talking about Prince? You guys obviously know that Prince passed away several years ago, much to my chagrin, and I'm still heartbroken over it. I grew up over Prince, but I added some slides with some entertainers here who, just had a lot of issues once they passed away with passing down their generational wealth, what I'm calling generational wealth, property, money. Prince died without a will. I was heartbroken. I'm still heartbroken over it. I can't believe it. Don't do that. We can plan for the afterlife. We can plan how our property should be passed. For years and years, his estate was tied up in courts. The only people who win in that situation are the lawyers. A lot of the estate, even when you have a will, even when you go through probate, the lawyers win. So I try very hard to advise my clients and everyone to plan. There are some planning tools that we're going to talk about today that we can utilize so that we don't get our estates caught up and hung up and tied up in probate, where we're spending all of the wealth that we've worked so hard, in our lives to obtain and that we want to pass down to our children, our families. So Prince is one example. Another example I'm sure you guys have heard about is Miss Aretha Franklin, who died without an estate plan. I'm told, in my research, we were told there were some wills, right? Some handwritten wills, but that's not an estate plan. So even if there is a will, we've got to go through probate. So they're going to be fighting in court, forever and a day to figure out what's going on with all of those wills that she had stuffed under, mattresses or wherever she had them, in a couch. I think someone was found. That's not valid. It's not something that we want to do. My experience, Miss Aretha Franklin, 76 years older, Black woman, right? A lot of times in my experience, the Black community in particular wants to keep things private and in the household. So, and I suspect that may be one of the reasons why she, had some handwritten wills and, didn't really want to talk about it, didn't really want to talk about her affairs and her plans for the afterlife. I also, in my experience, men primarily just don't want to talk about dying, don't want to talk about death, and so therefore really don't plan. So again, we don't want to do that, right? Don't want to do that. We want to have what we call succession planning. It's the processes, tools, methodologies you can employ to ensure the management of family and business affairs and to protect your assets and to distribute them once, according to your wishes, once you pass away. And this is a PowerPoint. If you guys, I have the handout so you guys can take some notes on the slides, but I can also distribute it to Ms. Lewis, who can send it to you guys via email if you like. So I'm starting out here talking about a will, because that's generally what people know about, right? It's like, if I get a will, I should be okay. So I wanted to talk a little bit about a will, what we call a last will and testament, and some of the key components. And then I'll talk about some of the other planning tools, estate planning tools, and sort of compare them, right? And then we can sort of talk about the issues related to all of them. So a will, right, it outlines the testator. With the testator is the person preparing the will. That's what we call that person, the testator. The testator's intentions after death. So I'm, want to draft a will. Miss Meredith Hammer, I want to draft my will. I don't have a will. I have a trust, but that's something else we'll talk about. I want to draft my will, so I'm the testator. So I want to outline what my intentions are going to be once I pass away. In order to do that, when you ask an attorney to help you prepare a will, you have to be of sound mind, right? You guys all know that. You want to identify an executor or personal representative. They call them different things depending on the state, to handle your affairs and to distribute your property after you pass away. And then you want to identify your estate assets, like your house, like your car. Those are estate assets. The fine china, all of the hundreds of thousands of dollars worth of jewelry. I don't know. Your car, your furs, those are your estate assets. All of your real property, like the house is called real property, and your personal property. And then you want to have a witness to the will. In Illinois, you need at least 2 witnesses. But here's the deal with the will. Even if you go through all of the rigmarole of hiring an attorney and having those key components that you need to have with the will, notice in red I highlight that probate is necessary. So what that means is that you got to go to court. Your representative, your family members have to have knowledge of the will, right? And they have to put it into probate, what we call probate, which means some extra fees. You have to hire an attorney at that point once you pass and tell them you have a will, and then they will draft all the necessary documents to put that will into probate. It's going to cost about $5,000 to do that, between attorney fees, which run about, in Illinois, typically run, that's with nobody fighting. That's with nobody, arguing. That's just, you got a will, and it may be one child or one heir. It may be a couple, but everybody has to be in agreement, right? Because when people start fighting and they start hiring attorneys, then we got another story. So typically, if there's nobody fighting, we've got about $3,500 we're going to spend in attorney's fees. And then the administrative costs, which include the court costs, putting it in the paper. You got to get a bond, about $1,100. So you're at between $3,500 and $1,100. You're at about $4,700. And that is if the administrative costs don't go up, or you don't have a crazy attorney, right? Who's not trying to, charge you all this money, because you have to go through probate. You have to go through probate in order to transfer title to the property. And the taxes still need to be paid on the property, right? The county assessor doesn't care that you're in probate. So I'm saying that to say, the house, depending on what the condition, with the taxes and insurance, depending on all of that, when you passed away, the house is at risk of being lost while you're going through probate. Probate could take a year, which is disappointing to me. In Indiana, it's much quicker, but for some reason, Illinois, it's going to take, once I put a will in the probate, it's going to take at least 2 months to get a hearing with the judge, just for him to say, okay, yeah, you've done everything right, and I'll sign the order to allow the executor who's been identified in the will to take over and administer this estate. And again, that's if nobody's fighting. If people are fighting, it could take years, which is what happened in the case of Prince and Miss Aretha. So a will is fine, and you can hire an attorney to spend $500 to draft a will. But then on the other side of that, when you pass away, your family has to probably spend about $5,000. In Illinois and Indiana, it's less, but it's still going to be at least $2,500, $3,000 between the attorney's fees and the court costs. So all is not lost, though. All is not lost, because there are some things we can do to mitigate, to mitigate those costs. And there are some other resources and tools we can utilize to pass property in Illinois and Indiana, in both places. Does anybody have any questions? I see everybody's kind of like, what? I got to spend all this money?
Does it depend on the size of your
No. So here's the thing. It can. If you have real estate, though, you have to go through probate, whether you have a will or not. If you have a piece of property that you want to transfer, you have to go through. If you don't have property and your estate, the size of your estate is $100,000 or less, that's $100,000 or less, your heirs can produce something called a small estate affidavit, which basically says, and I'll talk about that a little further on, but it basically says the estate is less than $100,000. I'm an heir of the decedent, the person who died. I can prove this by showing you my birth certificate. It was my mother. This is the death certificate of. So those kinds of things. So say there may be a bank account for $20,000, right, that you've learned about. That's under $100,000. So you can go, you can file a survivor's affidavit with the court, and you can then go to the bank and take the order and show them that you deserve to receive that $20,000. Does it make sense? It's a little messy, right? So I have some ideas about how to mitigate all of that. We can set up a trust, right? And I'll go through the trust just sort of high level, because it can be complicated, but then I'll go through some of the other lesser complicated tools. But a trust, I do want to talk about a trust, because it really kind of all depends on, what you want to do and how you want to set things up, and your heirs and kind of where they are in their lives. But a trust, have you guys heard of a trust? I like to say a trust and an estate plan, because a trust is one part of your estate plan. I talk about a trust and putting property into a trust, and real and personal property into a trust. But then there's also this other part of your estate plan, like a power of attorney, right? That should also be a part of your estate plan. A financial power of attorney and a healthcare power of attorney, which I will talk about briefly down the line. But I think everybody needs both of those, especially as you get older and wiser, right? In years, you need a healthcare power of attorney and a financial power of attorney, especially in times like we've seen with COVID and the pandemic, as people are becoming ill and just, they may become incapacitated. You need you need those kinds of tools. So a trust is, it's not an account. It's not anything more than a plan, right, of how we're going to handle and distribute your assets after you die. Kind of like a will, but different. So it's a document where we appoint a trustee to oversee our assets. It's a document. We have a document called a Declaration of Trust, where we have outlined, some key elements to distribute your assets after you die. You don't have to go through probate. First point, no probate, right? Because you set it up in a certain way. But this means that people got to know what they're doing. They got to know that you got to trust, right? Somebody, a trustee, right? A successor trustee has to know that you got one and what you want to do with your stuff, right? I'm just talking plain, right? With your stuff after you die. So you can't keep this secret, right? You can't be hiding under a mattress. You got to talk to your family, your trusted family members or friends, somebody you trust. So what we do is really very simple. We have the trust document. The trust can be amended. So we call it a revocable living trust. You're the trustee while you alive. So you have the power to make changes, right? To sell your property, to buy more property and put it in the trust. You have the power. But then you identify in that trust document someone who's going to take over for you when you die. Right? Like your grown child who is you trust. And so when you pass away, so what we do is while you're alive, we and you're the trustee, we transfer everything over into the title of the trust. So like your house that's in your name, even if there's a mortgage on it, we can still transfer title. So if it's in your name, we transfer it to the revocable living trust of, what's your name? Terry? What's your last name? Campbell. The revocable living trust of Terry Campbell. That would be the title on your house once we transfer it to the trust. Via quitclaim deed, we transfer from Terry Campbell to the revocable living trust of Terry Campbell. It's now in your trust. And you as the trustee have the authority and power because we've identified it in the trust document and according to the trust laws. You have the power to sell it, to do anything you want to with it. And then when you pass away, so does your successor trustee. Because we've identified the successor trustee, who could be Meredith Hammer, who could be Miss Margaret Lewis, who could be your daughter or your husband or someone that you've identified in the trust document to be your successor trustee. And once you pass away, they automatically are able to sell it, to do whatever they want to with that property as your trustee. The trustee is a fiduciary. The trustee is a fiduciary for the beneficiaries of that trust. Someone who is trusted, who's responsible, who has to act in the best interests of the beneficiaries. So you could have a fiduciary with the trust. In the case of a trust, you could have a fiduciary in the case of a will, like a personal representative. You could have a fiduciary on your insurance accounts, right? The fiduciary operates in the best interest of the beneficiaries, just generally. In this case, the trustee, successor trustee, the trustee who is you while you're alive is also the fiduciary of the trust, of the beneficiaries of the trust, right? Because even though it's your stuff, right, you are still operating in the best interest of the beneficiaries who become those people, your heirs, right? And so the successor trustee to you is going to operate in the same fashion, in the same manner as the fiduciary. Make sense? Yes, ma'am. They can be if we identify that in the trust. A lot of times what happens is the successor trustee is you, right? Or a family member, and they're acting like a personal representative would in a will, right? So same thing in a will situation, the personal rep or the executive of the estate can get paid a reasonable fee, right? In Illinois, there's this something called land trust, and there are these land trust companies, right? So they get paid like, whatever, $100 a year just to maintain the trust. And typically, once you get it set up, there's nothing else to do, right? And that's something you could do is set up the land trust, or you could have an attorney prepare it and do it privately. That's the thing about trust is that they're private, right? But again, if it's private, it can't be only just it has to be like private in your family, right? And so that when you pass, the people that you've identified or the person that or people you've identified as the successor trustee knows what you want to do. They know what you want to have done with your property. There's no going to court. There's no fighting because you've identified the successor trustee and you funded the trust. So these are some of the things we got to do, right? And the trust document, while you're alive with well, sound mind, and everything's hunky-dory, right? We have an estate plan. We set up the trust. You meet with an attorney. You tell them, you identify yourself as the trustee, a successor trustee. You got to fund the trust, which means we have to transfer title to your property, to the trust. If you don't do that, you got to go through probate. That's a key component that a lot of people miss. I had a client one time that very recently, long story short, because I can have some long stories with my clients, but I had a client whose sister, they came to me, and their sister, whom I knew, had set up a trust. Well, she had a trust document, 9 years, for 9 years. But the attorney she used never funded the trust. So we had to go to court. Still, it was like she had done nothing. She had 4 pieces of property, and it was a scramble. I'll tell you more about it, but later. But she had gotten sick and was in the hospital and had $1 million in hospital bills. So you can imagine if we've got property and she can't pay her medical bills, and we got to go through probate. Guess who gets her property, even though she had a trust. So it took me 2 years, and she had 7 siblings. And because I'm a good person, and I knew her sister was my teacher back in high school, we didn't lose anything, and I didn't, we didn't go crazy with the legal fees, but I didn't get paid for 2 years. And they paid me some money, but it was a nightmare, and it just didn't have to be that way. And we ended up settling with the hospital for like maybe $200,000 or $300,000, which was a huge savings, right? And she kept all of her 4 properties that she had. So we figured it out, and we found money and found accounts everywhere, but still had to go through probate. Yes. So this lady right here was first. Yes, ma'am. No, you can get, if you have everything in order, because what I like to do is take a little time and let people think through some things. I mean, it could take 2 weeks max to set up a trust, to get everything transferred over. It doesn't take but 15 minutes to set up a deed and then to go record it with the recorder's office. And I think it costs $98 to record it with the recorder's office. So it doesn't take long to set everything up and to transfer property over, if that's what you want to do. Ms. Terry.
I set up a trust in 2000, and it included residential property and commercial property. I got rid of the commercial property, and the fact that it was in a trust became obvious during
the transaction.
But recently, speaking with someone to update my estate plan, the question was, with the resident that I'm in, and the same attorney, even though it was bought later, was supposed to have put it in a trust, it was brought to my attention that on my tax bill, it should be listed with the trust as the owner, and that is not the
That's
case.
correct. So what I always recommend is that you take a look at your life every year, right, and see what changes have been made, and you update your trust. Now, your attorney ain't gonna know what's going on with your life, right? You may have a baby, Ms. Terry. And you may need to add them as a beneficiary to your trust. I'm joking, obviously, right? Or someone who you've identified as the successor trustee, for example, may pass away or may get sick and not be able to. But the way I set up trust, we consider those kinds of things in the trust, but that may happen. So I'm saying that every year, like you change your batteries, right? You check You do like a temperature check of your life and any things that have changed. I mean, I'm serious about it. Like, you've got to be on top of things. We have to be involved with our own lives and how we're wanting things to do and transfer in the afterlife. This is how you create generational wealth. And if you don't do it, you're going to lose it. Yes, ma'am. Yes, you can. Yeah, you can. And I recommend it. They're called alternative successor trustees. And you can have co-trustees. I don't necessarily recommend it, because if they get to fighting, we back and go it, right? So that's why I say you have to kind of take a moment, right, to really identify some things and set. There are some other tools I have, though, too. You may not need a trust, but you still want to transfer your real estate after you die without going to court. So I don't know if I answered your question, though.
Okay, since it's not listed, this house I'm in on the tax bill, that it is a trust, can I do a toady, or do I need to?
So a toady is something totally different. You don't need to do that to get it listed on your tax bill. We just call the taxing authority and talk to them about why it's not listed. It doesn't, I mean, it's not a requirement, because they're going to take your money still, right? So it's not anything that's illegal or something that's going to change your life, right? We just call them and talk to about why hasn't been updated. It just could be an oversight. They do that all the time.
Thank you.
So real quick, briefly, these are some of the things, and you guys have them in your notes, that you could consider in setting up your trust speaking with your successor trustee. You want to talk to them about your finances, your taxes, your legal. You may have multiple businesses, medical situation that they need to know about. I'm just briefly going over that because you guys all know this and can imagine. You need to let your successor trustee in on your life, right, and the happenings that's going on with your life. Yes, ma'am.
So even if you have a trust set up already,
Yes.
you need someone to oversee it?
Well, you're overseeing it now if you're alive, but you should have identified someone as the successor trustee. Do you have a land trust? If you may have a land trust, so the company who is managing that land trust is the trustee, but you give them direction as to what needs to happen with your trust. You're technically the trustee. They probably are the co-trustee or successor trustee. It just depends on what's in your trust document.
Hopefully a quick question. What defines property? It's not just real estate.
It's a list of the assets, right? Trust schedule. It's a trust schedule, we call it, which should be a list of your assets. And your attorney should go over this with you. I mean, I can't stress enough, because if they don't, it's like you wasted your time and your money. Your trust assets and your list of your assets and your trust schedule has to identify the assets. But more importantly, we've got to fund the trust. We've got to transfer title. So you could have real property, your house, and investment property. You can have investment accounts. And so it depends with the investment accounts. It depends what they are. A lot of times, if you have a beneficiary on those trust investment accounts, you're fine. They don't need to be transferred to the trust. But it can get complicated, right? It just depends on how, depends if they're charitable account. I mean, I don't know. It can get complicated. I don't want to get so complicated. I do like to list everything, all of your property, though, on the trust schedule, so that your successor trustee or trustees don't have to go looking for it. Why wouldn't we put it all in the same place? So technically, when you die, it should be take you a minute, right, to go get the book, right? And I've seen this. This is the reason why I'm recommending it. I've seen this done the right way. My own family, at the risk of getting too emotional, which we don't want. When my mom passed away, she had a trust, and it was, my dad just said, go get the book. It was, I can't tell you. I could never tell you how relieved I was until it happened to me that this is what we had set up, because my mom died unexpectedly. She had a heart attack and passed away, but we didn't have to figure stuff out in a time of grief. It was just, everything was set up. The funeral arrangements, I called them and they took care of it. Everything was set up. The bills were paid. My dad is the best father in the world, but he had everything. I just can't explain to you that I told you I was going to cry, just how it was just set up. And so we were able to grieve and come together as a family instead of fighting, you know. So I apologize. Automobiles, bank accounts. The bank accounts, see, we don't necessarily have to include them in the trust. You guys have heard of payable on death accounts, right? Where you go to the bank and you put your person, right, who's going to take over that money after you die, you put them on the account. That's called a POD, a payable on death account. But still, we want to list them in the trust at the schedule, right? So that the person know where the bank account, we got the bank account, the bank number. So when we go to the bank, it's just like, here you go, I'm the POD. Give me the money. You don't have to go to drama, no stress, no court. A power of attorney won't work when you die. A lot of people tell me, well, I got the power of attorney. Okay, but the person is dead. See, a power of attorney only works while the person is alive and incapacitated. They may be in a coma, so you can handle their affairs. But once that person dies, the power of attorney expires. So I've had people tell me that, like I said, the person has died and I've got the POA, so I'm going to the bank. Well, it's too late. You got to go to court at that point. You have to go to court. If a person is incapacitated and you don't have the power of attorney already existing, what you gonna do? Because the power of attorney says, and we'll get to that, I'm getting ahead of myself. The power of attorney says, when I become incapacitated, make this person my power of attorney. So you have to sign that. You can't sign it if you're already in a coma. So you got to get this stuff done while you're alive and well and in sound mind. Other assets include automobiles, like I said, and jewelry and personal property, and even like animals. If you got a dog like me, you know those are considered property, right? So you want to make sure that somebody knows who's going to get them. You want to keep these up to date. Let me finish this. You got to keep it up to date. You got to keep it up to date. So every year, depending on what's changed, you may have bought a house, bought some investment property. We got to put it on the trust schedule. We got to transfer it to the trust. You just got to do it. Call your attorney, and your attorney's going to have a copy too of everything. So just in case something happens to the safety deposit box, you put everything in. You've had a fire, your attorney got everything right there. And so your successor trustees need to know who your attorney is. Don't call Meredith and ask me what to do, and I don't know nothing about what's going on. I'm just going to tell you the truth. Yes, sir.
Should there be a simplifying document? All my affairs, all my
Yep.
assets to my wife. She passes them on down to my son.
So that's a trust. This isn't books, right? The trust probably is 7 pages, and that's including like 2 pages of signatures and notary. And then you've got your list of your assets. So your wife would be your successor trustee, or you guys would be equal successor trustees. So something may happen to her first. We don't know. If it happens to you first, then she becomes that's the way we set it up. It's simple. I think it's simple. But you want something simpler?
No.
Okay.
When activate it, you don't have any problem.
I agree. I hear you. That's what a trust is to me. Now, and then within that, there's a state plan. We want a power of attorney because I'm an attorney, and what attorneys do is think of hypotheticals. And I know what you're saying is it's simple. I'm gonna die and she gonna take over. It may not happen like that. You may get sick. You may be in a coma. You know what I mean? So we have to account for those. So we have to have some conversations. It doesn't have to take long, but we have to, based on my experience or whoever attorney you trust experience who can do this properly, based on their experiences, they can set it up. They probably already have some templates set up. I'm not drafting from scratch every time, right? It's got to be according to the laws of the state of Illinois. And we're setting things up and we're sort of filling in the blanks, but some of it is customized to your needs, right? But it's not long. So this is a power of attorney. We've already kind of gone over it. Financial power of attorney, as I stated, gives, you identify a representative called an attorney in fact, an agent who is going to handle your financial affairs in the case where you become incapacitated, like being in a coma, or you can't handle them yourself. You can't speak for yourself. And the way that the power of attorneys work, the way I draft them, you are deemed incapacitated when your doctor or team of doctors say you are, not when like your kid says you are, right? That when your team, that's the way it's set up, and that's what you sign off on, right? So you've got a power of attorney. Durable power of attorney, it's a file financial power of attorney as part of your estate plan. It's a couple pages long, right? You got to get it notarized. It's in the book. Yes, ma'am. Oh, those cars are, the Secretary of State has like a, I can never remember what it's called, some sort of beneficiary form. And you, as we're doing this estate plan, you identify the trustees and the beneficiaries. So your successor trustee would handle that. And there's a document that we file with the Secretary of State with your cars, like the VIN number and things like that. And so it's on file, but it's included. They become a part of your trust. And your successor trustee handles the distribution of those, or whatever, according to the trust document. Yes, sir.
Does the trust, is a trust predicated by the total amount of money or assets?
Doesn't matter. It doesn't matter how much you got. It can be, $100,000 if there's a house, and then or $1 million or $10 million. But as you can imagine, when you have millions of dollars, people tend to want to. It can get complicated, but it doesn't matter how you set it up according to the laws, right? Is that answering your question, or I think you're kind of thinking?
It somewhat answers my question.
Somewhat, okay.
I said it somewhat answers.
Yeah. Do you want to tell me more, or?
Well, I have inherited.
Okay, we can talk about it one-on-one because it's personal to you. We'll talk about it one-on-one. I can hang around, right? And my number's at the back of this. And I'm open to you guys asking me questions. You don't have to, do business with me, but I just like to give people information at the risk of my own me eating. Well, I found, but you can. I just think people need to know because we need to create generational wealth. We don't need to be losing our stuff just because, right? Just because we don't know, because we're afraid to talk about it, because I don't know, whatever, I don't know. But it just doesn't make sense to me because it's not that difficult and we just haven't had the conversations. So these are, and this is in your packet. This is the kind of person we need to talk about identifying as our agent or attorney. In fact, on a power of attorney, they got to be 18 years old. It can't be your teenage grandson, right? So we know that someone who knows you well, someone you trust, someone who won't be too upset. And I say this because someone who won't be too upset or emotional when you get sick. We're handling business at this point. And so it just it's not going to be, just terribly emotional, although it may be for you. And I'm saying this too because we identify an attorney in fact or an agent on the healthcare power of attorney. So it's according to your wishes, right? So I'll just go through this slide because we're going to talk about a healthcare power of attorney in a little bit. But this is about advanced care planning, particularly related to, older individuals and healthcare decisions. So I've got this section in here. We don't have to go into a lot of detail, but we want to consider this. Ain't nobody getting no younger. I'm 52, right? And like I said, we just went through an age of health care crisis, right, with the pandemic, and people were just in a coma and dying, and just unexpectedly. So we want to consider what we call advanced care planning. It's healthcare related, and we want to talk about here what sometimes we'll call a living will. It's not the last will and testament. It's a healthcare power of attorney. It's an advanced healthcare directive. So, for example, what do you want to have happen in the case where you get sick and you are in a coma? You could have an accident and be in a coma. Do you want a feeding tube? Right? Do you want life-saving measures? My mama did. She was like, I want to live. Right? I don't. Don't do any of that to me. So we have to understand what you want. This is according to your wishes, right? You have to identify an agent or an attorney in fact in this situation too. It can be different person than in the financial power of attorney. But just because you've identified somebody over there with the financial power of attorney, that don't mean they're going to be able to serve over here just because you got that financial power of attorney over there. The financial power of attorney is for the finances. This power of attorney is for the health care. So it's a separate document, but it's also a part of your estate plan. We call this person an agent or attorney in fact, right? And, a lot of like senior facilities and things, they have these kinds of things already set up. They have templates. If you have a doctor who is, pretty savvy and aware and cares, they will have probably already talked to you about this. But this is important. And this is, again, a very straightforward process, a straightforward document. We identify the attorney or agent in fact. We have some things listed on that document about how you want things to be handled with regard to your health care when you pass. Like I said, feeding tube or no, life-saving measures or no, those kinds of things we want to outline. But it's very important that we identify an agent or attorney in fact who, like I said, is going to be someone who can carry out your wishes for you and your health, and who won't get too terribly upset or emotional when the time comes, right? When my mom passed away, she had a heart attack. She was in the hospital. My sister was her healthcare power of attorney, and I trusted her. My sister is a nurse, but she called me because I was here. My mom was in Indianapolis, so I didn't see my mom before they took her off. They tried to save her, and I was here on my way there, and my sister called me and said, what do you want to do? I'm calling everybody. I said, the doctors were trying to revive her. And every time they brought her back, she would do what they call breakdown. I said, we're not putting mom through that, even though I wasn't going to get to see her. But I don't regret that. So she made the decision, but she did call me. And she said, she, the nurse, the one who had been in the healthcare, she was like, I can't do it. It just, when you get into that point, it's a lot. And she experienced a lot of guilt over that even after the fact. My brother, my other sister, all the kids were there. Everybody's crying and freaking out. I'm over here, and it was, I was relieved to know that I was here and able to tell her we're not doing that. We're not. And so it was, the grace of God allowed me to be separated and not experience the guilt. I'm sorry, y'all. So, when you lose your mama, it changes your life forever. So, thank you for bearing with me. I was well loved. That's what I would say. I was well loved, and I have the best father. He's still alive ever. So, so this is what kind of things can my healthcare agent do? just so you know, your healthcare agent, who we identify in the healthcare power of attorney, can talk with your physicians on your behalf, see your medical records. See, these are things that they wouldn't normally do. If you don't have one identified, people can't get your information, give permission for medical tests, emergencies. If you're in a coma, who's going to do that for you? The doctors don't want to do it. They don't want to be making decisions for your health care. I mean, because they have to, right? You know, but they would want to know what your wishes are. But when you're in a coma, obviously, choose where you receive care, decide to accept or withdraw, or decline treatment, decide what to do with your remains. You know, that this has to be spelled out to your agent, right? I want to be cremated. I told my parents, don't, I'm coming back to haunt you. I don't want you doing the funeral thing. It's just my personal preference. I don't want nobody to spend no money on me for that. I know that's for the living, right? You can have memorial service, but don't do the funeral. I'm adamant. And, you know, talk to your loved ones and keep them up to date about decisions. So you want to have somebody you trust, somebody who's going to carry out your wishes. These are some of the things you want your healthcare power of attorney to know. And I included these, and we don't have to talk about them a lot. I just wanted you guys to think about it. It's just generating some thought. You know, do you want a DNR? Do you have a DNR, or do you want to have a DNR? Do not resuscitate. I know one of our family friends, she didn't want to be, you know, resuscitated. She didn't have a DNR either, but her son, her adopted son, was her healthcare power of attorney. And he asked me, and I told him, I said, as far as I know, Mrs. Lee, you know, she didn't want to be brought back. There's something in the Bible that talks about, was it 70 like 70 years. She had lived beyond 70 years. So that was her thing. She was like, I'm done. So these are some of the things that you would want your healthcare agent or power of attorney to know, whether you want ventilator support. Obviously that was big during the pandemic, right? And you know, your religious beliefs, you have religious, spiritual beliefs that will come into play. And you know, how important is it to you to avoid pain and suffering? So these are some of the hard maybe, but necessary conversations. And I think a lot of times, as I did earlier, especially men just don't want to get into the conversation. That's just been my experience. So an estate plan from me has a trust. We fund it. It has a power of attorney, a durable power of attorney for financials or finances, a healthcare power of attorney. And the last thing we have is a pour-over will. And you're like, what? We talked about a will. We got to go to court. So here's the thing. A pour-over will is just that it handles anything that pours over from your trust. So what happens is, let's say, Ms. Terry, you win the lottery right before you die. You got your trust set up and everything is in order, but then you win the lottery and then you die. What do we do with those lottery winnings? Because we haven't had time to put them in a trust. So we have a pour-over will that says, if I win a lottery, or if I come into some money right before I die and I ain't had time, it don't say it like that, you know, but I haven't had time to put it in my trust, just put it on in the trust. So we would go to court, summary proceedings, and say, here's the pour-over will, and we got a trust over here. And the judge goes, oh, okay, you did some good proper estate planning, so we don't have to have no fighting. We just gonna put it in the trust. And so that's what that means. That's what that is. We'll have to go through. So we have a 4-page pour-over will that says just that, and we've got to, you know, take care of getting it signed with witnesses like we would a normal will. We'll have to go through probate in the case you win the lottery, right? But again, we want to every year, annually, we want to be making sure we've already updated everything so that this is, you know, that in case scenario, just in case I win or I inherit or something happens right before I die and I don't have time, go ahead and pour it over. Make sense? You can do a will and then you can do an estate plan. Those are the two different categories, in my humble opinion. I'll be happy to set up a will And, well, I don't even do them anymore. You can do a will. You can get a will offline, right? You can write your will on a piece of paper. You still don't have to go to court. So I want to talk briefly about some other tools. Ms. Terry mentioned this transfer on death instrument, a TODI. A TODI is like a 2-page document that basically says, I have a property. That's all I got. That's all I care about. And I'm going to transfer this when I die. It's transfer on death. I'm going to transfer it to my daughter, my wife, when I die. You draft it while you're alive and record it with the recorder's office like you would a deed. It costs $50. You can get a template offline from the Cook County Recorder's Office. You can call me. I'll help you step through it. You have to get it notarized. You have to sign it and then record it. And then once you die, you don't have to go through court. But what you do is you have to go, the person who is receiving the benefit of the property that's being transferred has to just go file a survivorship affidavit and say, I have this document, this TODI, and they can see it in the recorder's office, and this is who I am, and the person who's transferring this over to me died, here's their death certificate, and you attach it to that survivorship affidavit, and they record it, and the property gets transferred to you. In that matter, in the chain of title. That's very simple, very easy, very straightforward. But that don't include anything else. It doesn't include your personal property. It don't include nothing else. It does not. That's all it includes. It's whatever is listed, the house on there. It's very straightforward, very simple. So if you don't do anything else, you can do this for your property. And it's cost effective, right? You don't have to go through probate. Let's say a couple $100. You may have to, talk to an attorney who will charge you, $150 for an hour. I don't know. I'm making it up. You can go online, but ideally you want to have someone look over it who knows what they're doing. But the Cook County clerk, I'm a community partner with them, so we talk about this when we do these property after death seminars, which I will share their website with you at the end, and they have like this traveling bit where they go around. I don't know if Karen Yarbrough is still doing that, but they were last year, where they would go around to different locations throughout the county, or even do it online and talk about the same thing. And there will be a lot of people there, but she's big on these TODIs, because it's very straightforward, and it costs about $50 to record it. But you want to make sure what you're recording is right and in proper order, and it's legal, right? Don't let an attorney tell you something different, okay? Don't let somebody who isn't an attorney tell you something different, right? You want to make sure that you go to, and you can go to the county clerk's website and see what a TODI would look like. So just be informed with these. But no probate is necessary, and they're very straightforward. So if you just have a house, and you can still have a mortgage on it. Now, ideally, if you have a mortgage on the house and you want to transfer it, you want to call the mortgage company before you do that, because some cases, and certainly it's not often, but in some cases, the mortgage note will have an acceleration clause in it that says if you transfer the title to the property, they'll accelerate the mortgage. And of course, we don't want that. So I always call the mortgage company before I do any kind of transferring of property to the trust, or anytime I'm messing around with the title, I call them and I say, well, for estate planning purposes, this is what we want to do. Is there any kind of provision in the note, the mortgage note, or in the mortgage documents that will prevent me from transferring title? So that's another reason why you want to hire an attorney, because a lot of this stuff is based on experience, right? You want to hire somebody who knows what they're doing and has experience. So that's a TODI. They call it a TODI. See, transfer on death instrument. Have you guys heard of those? I know you have. Anybody else? Yes, ma'am. Is the TODI? Yes, real property, real estate, like your house or, yes, only on property. Yes, ma'am. Then I mentioned already payable on death accounts with the bank. They call them a POD, no probate necessary with those. You go to the bank and you say, I want to be listed on here as payable on death.
Now, do you roll those into a trust?
No, but you list them as assets on your trust schedule so that if you do set up a trust, and I just encouraging having a list of your assets. Any case, you got to have it somewhere because you're going to be dead and gone, right? You're the living. This is for the afterlife. This is for those people living, so we can pass on our wealth. That's what this is for. It's estate planning. So this is a payable. You want to go to the bank. You want to make sure you have someone listed. You want to make sure the person you have listed knows that they listed and where to go. And you got to have that done. Yes, sir.
I have my wife on my account.
As a payable on death account. So,
This is my joint account.
well, so you should be fine. But here's the thing. What if something happens to her first? Right, and then what happens? So I'm thinking of hypotheticals. So if something does happen to her first, this is what you do. You have to, remember this is annually. But if something happens to her first, you got to update that payable and death account and put somebody else on there. Make sense? You need to have a trust and estate planning attorney in your wheelhouse as part of your resource. Somebody you can call and say, what? And you don't have to pay them necessarily, but it's certainly if you set something up like this with that person, you should be able to call them a year from now and say, look, this, they're your trusted family attorney, right? So they're your trusted family attorney. Yes, sir.
I have my friend that I refer to.
Great. He's a trusted family real estate, trust and estate planning attorney.
Yes,
Awesome. Is he here?
he's here.
So he knows Illinois law. Okay. Did someone else have a question? Is this helpful for you? Okay.
He's been helpful, but he also does that for the fraternity.
That's wonderful. That's wonderful. Yes, ma'am.
The person that I had was recently going over with told me to take the individual off as the joint owner of my bank account and make them the beneficiary and to do the POD.
Yeah, that's what I would prefer.
More sense was, and when he explained it, it did.
Yeah, because he's dealing in hypotheticals in his experience. So it's like I said, it makes more sense. Because if something were to, you understand what she's saying? Yeah. So it's totally up to you, but it is what I would prefer and recommend. Does it make sense? I know we're having this conversation over here that's specific to them, but does it make sense? I just recommend a payable on death account, and that's what that is.
Your money can't slip away from you while you're still here.
That's right. But see, he trusts his wife. What you trying to say, Miss Terry? You don't trust his wife?
It's my son and he got married, who knows?
I know. Well, listen. I hear you. And see, those are those sensitive conversations. You know what I mean? That you want to be having in private. So I mentioned this earlier because I think, what's your name? Miss Cheryl asked about. You look familiar to me too. Now that you took your face mask off, you asked about the car. So there's this Secretary of State beneficiary affidavit. That's what I can never remember the name of that. And so it's a form that you complete. I do it as part of this whole estate plan that identifies the beneficiary after you die. The thing about these is the car has to be paid off, right? So that's why in the case of a trust, when you have a trustee, once that car is paid off, that's a triggering event, right? Where then you have to get this Secretary of State beneficiary affidavit completed and filed, because you can't do it before the car is paid off in the case of an automobile. Right? Yes. Yeah. Again, it's a triggering event. Yes, we put the VIN number and everything on there. And then there's no probate necessary. Not that there necessarily would be, you know, just in the case of a vehicle, because, you know, if that's all we had, right, and didn't have anything else. But we don't have to go to court to do this. We're almost done. I know it can be a lot at first, right? But it's something we gotta invest in this. We gotta invest in this. So this is, I've already said this to you, we're actually really done. This is estate plan and the key components. I talked about a trust document, I talked about the trust schedule, and I talked about funding the trust, I talked about a TOTI, I talked about a healthcare power of attorney, a financial power of attorney, and a power of a will. I just included everything we've talked about in this one slide. Some key documents for simple estate plan. And you could have a mixture of some of these. You definitely have to have the trust. If you're going to do a trust, you got to have a trust, fund, trust, healthcare power of attorney, financial power of attorney, and power of a will. A TOTI can be done on its own. Yes, ma'am.
So if you have car, furs, jewelry, you should,
And no real estate, you should add those to the trust. You should have you should list them on your trust schedule.
and if you have investment accounts, those should be listed on.
Yes, ma'am. Everything, any kind of property, which includes anything you own that you want to pass down, needs to be listed as an asset on that trust schedule. Everything. China.
So you would only need a trust and a pour-over will? That would cover
Everything. Yeah.
everything? Okay.
I add the that's considered an estate plan. And so to that, I would just make mention of a POA, both financial and healthcare. So 4 things: trust, power of a will, healthcare power of attorney, financial power of attorney. That's an estate plan for a simple estate. Yes, ma'am.
Not all your property are
Yeah.
foreign property.
We got to talk about it because I'm only here. I only know the laws of the state of Illinois, Indiana, and DC. I would list it, but then you have to make sure that I would list it because, you know, you're here, you have the trustee who may or may not be here, but you want them to know about it. But then you also have to maybe do something different with how you handle it, especially if it's out of the country, right? You got to do something different. And if it's out of the state, you have to do something. The law in Louisiana, they crazy down there in parishes. I don't know what they do down there half the time. I mean, I get people asking me, I'm like, what parish? I don't. So, I'm joking, but what do they call it? Laughing, but kind of serious, very serious. But I'm not licensed there, so I can't give you any kind of advice in a jurisdiction that I'm not. But I would recommend at least listing it on your trust schedule and then talking to your attorney about how to handle that, separately from the laws of Illinois. I mean, it could be anywhere, like California. Like I said, a lot of people, especially older Black people, have property in multiple places. And they'll have 35 million siblings, all on title. And inevitably, that's not a good estate plan. They lose the property. And, I've had even a client the same people who were, had the sister who they have, it's 7 or 8 of them, their father left them some oral rights. I'm hitting this, some oral rights. And they have spent a lot of money over the years to receive the money from those oral rights. And it's like pennies on the dollar. And it's just, in the property, it's the same way. A lot of the property, especially in the southern parts of the states, I don't know. Like I said, I don't know if people just, trusts don't exist. What happens is they tend to put the kids all on title. And see, that's not a good point. That's not good. Even while a lot of people do that. They'll put, if they have 2 or 3 kids, because what happens is if you're on title, anytime you put someone on title to their property, any of their creditors attach. So if you have 2 children who everything is fine, right? But let's say they file bankruptcy or they get in financial trouble and they've got creditors. If that person's on title, you can't be like, oh, I'm gonna take them off and hope that they know. It's the law is that because they were on title, when they were on title, if they have something that they're a debtor or a creditor, it will attach to that real estate. So before you sell it, like they would have to, before it passes, right? Before you got to pay off whatever debt that was. That's another way where generational wealth is lost. So you don't want to put people on title to the property. I just don't recommend it anyways. You can put a business on title. See, essentially the trust is a business. It operates like a business because you want to keep it private. You want to keep it out of the public record. You want to keep it out of the courts. I'm just telling you. I'm not telling you to do anything illegal. I'm just telling you how to create a good estate plan that will help you pass generational wealth. Because, I know we love our kids, but they be doing some foolish stuff. And sometimes people don't even know. They get caught up, SSNs, identity theft. They may have been in a situation where they've had their identity taken, but your property then got caught up. Your family estate then got caught up. So I'm just saying that it's the proper estate plan is to not add all your kids to the title. The other thing I will tell you just briefly, I love property. I love talking about, is that say you want to put your 2 kids on the property and they are great. They're never going to get in any trouble. They're never going to have creditors, but you don't put them on there as joint tenants with rights of survivorship. Have you ever heard that term? So because joint tenants of rights of survivorship is like a husband and wife being on the title. So when one of them dies, all you got to do is file a survivorship affidavit. So if you put 2 people on there without that language, then they act as tenants in common. So guess what? When one of them dies, you got to go through court, and their heirs take their interest in that property. Their heirs. So if they got 10 kids, you got 10 people fighting over with that other person on title for this one property. I got a situation like that with a family in Indiana. It's ridiculous. The property ain't worth $50,000. It's 4 people on title. They forced me to do that. And one of my sister's friend's mother is getting ready to go. She's going through dementia. And I think one of the siblings has like 9 kids. It's $50,000. So that is not something we don't want to put people's names on our property to pass it, even if it is a joint tenants with rights of survivorship. But if we got to do it, that's the way we're going to do it. It's JTWS, joint tenants with JTWRS. Even if you just put those words on there, that makes a difference. You know what I mean? This is that survivorship, mysterious survivorship affidavit I was been mentioning, where you file, if you have a title where you've got the 2 people as joint tenants with rights of survivorship, then the survivor files a survivorship affidavit. If you have a toady where you've transferred the property after death to the survivor, then they have to file a survivorship affidavit with the recorder's office saying, I'm the survivor to this property. Here's the deed. That referring back to, or go look it up, and here's the death certificate. You file it with the recorder's office, and then you take title to the property without going through probate. Yes, sir.
That was my plan of attack.
Joint tenants with rights of survivorship?
Yeah.
I mean, I think you should do an estate plan. You don't have anything else, just your property?
I'm the last one. My family, with the exception of my wife.
I hear you. But again, you could do a toady. You could do a toady and put or you could do the deed. You guys are on the deed, both of you?
Yes.
You on their husband and his wife?
Yes.
It's already done. So if you die, then she just has to file a survivorship affidavit.
That's what I have planned.
I mean, what you probably gonna say is, we just gonna give it away before we die or something like that, right? Or we don't.
I just come to her.
Like, so what is it? What are the other things?
My investments, my
They're all on there.
My car, my truck. I did have a boat, I no longer have a boat.
If something were to happen to her first, I'm just her first, and then you were to be sick, it's not recommended, but it's totally something that may serve you well. I don't know. I'm just, my goal is always to just make sure my clients' assets are protected in the best way that I know how, and I advise them, and then you do what you think is best for you and your family. But you can totally do it that way. But maybe if you want to talk to your frat brother, if he's advised you, has he advised you to do that? He knows you well. It sounds like you're covered. It's because he knows you. And what I was going to recommend is sitting down and talking to you about it. Then I'm talking to the head person in charge over here too. So if you want to call me, so you can call me. You can call me, and we can talk about it more one-on-one, just so you have peace of mind. Yes, Miss Terry.
You mentioned the attorney having copies, and my dad died as a resident of Ohio. I was his executor. I grabbed his stuff because he told me where it was, and I got it. They confiscated my bag. That's when they started that TSA, and it had to be checked rather than carried. I never saw it again. The attorney did not have a copy.
That's not good.
And we ended up in probate. So I said, the attorney, if by law he didn't need to have one, we as people need to know we have to have multiple copies.
Absolutely.
We need to know where
I always recommend putting it in a safe deposit.
to find it.
I always recommend putting a copy in the safety deposit box, and then your successor trustee has a separate copy too. That's in a trustee. So you've got and then your attorney. I will scan everything in and put it online. Right, and then, but again, like you said, just in case. But something could happen to me. You know what I mean? I could get sick. That's never gonna happen. But I'm not gonna put it out there. If you got a business, this is something you may want to consider. It's in there. I don't know if anybody has a business, but your operating agreement needs to have some succession planning in it. If you have a business like an LLC, you want to make sure that your business can be survive or not if it wants to be dissolved. Because typically, if you have like members in a business and somebody dies, the business dissolves. That's the standard. But you may want it to survive your death. So you want to make sure you include make provisions for that in your operating agreement is what it's called. I just want to put that in there just in case you guys, somebody asked the question. And if you have a business, and it can get complicated, as you can imagine with businesses, but it don't have to be. We talked about case studies already. And then Miss Terry's been, and then what's your name? Mr. Calvin's been talking about some stuff that people have been doing. He's been doing it personally. So that was the thing there. And then this is the website that I mentioned. It's Karen Yarbrough's off our Cook County clerk. She does, this is recordings website, but you can go to her website and get information about the property after death seminars that she may or may not still be having. This is particularly related to researching the recordings. You can search by address, by PIN number. There's something that, they know about in the record. People are stealing people's property. It's like property fraud is big, apparently in Illinois. So she has something that she set up called it's Fraud Alert, where you can register with her property, with her office, and in the case where your property may be the title may transfer, a deed may be filed with the recorder's office, it will trigger an alert that they will send to you. They will call you, they will email you, and they will text you if you have all of those options for them to contact you to let you know. And this happens. I have a client that I stumbled upon where their property, it was only because it's in disrepair, and the city of Chicago had identified it as, in their housing court. And so they did title search and reached out to the family, and they didn't even really know the property was still around, but their grandfather had this property. And Sylvester and I think banks, and this company had a deed. Guess what? Saying that Sylvester Banks had transferred to them. Well, Sylvester Banks been dead since '93, and that was recent. And so the housing court, the corporation council, had contacted them. So that we've been in a situation since March of last year. But I'm working it out. There's taxes and stuff on it. We've got to go through probate court to get that house as a part of the estate, his estate. We have to go through probate court. And it's probably worth $20,000, if that. And then the people who did the fraudulent transfer backed off, right? They backed off after they put the water bill in their name. It's crazy. Anyways, but they're getting ready to buy it from us. Legitimately. So, fraud alert, go to the Karen Yarborough's office. You can call her. I do want to mention that because this is happening, the property fraud, and you need to know about it. Like I said, this is an investment. This is a knowledge investment in ourselves and learning about this. And then this is my number. That's my email address. You can call me. That's my mobile number. So after 7, I may not answer. I may text you. So I hope this has been helpful. I hope you guys call me and just, take care of me.
I was talking with my daughter about, I'm 79 years old, so I was trying to explain things to her. I said, you have to pay to keep the water on in the house, you have to pay to keep the heat on in the house, and you have to pay my Visa and my Discover card. And she goes, but if you're dead, I can understand keeping the stuff on in the house until I sell it. But if you're dead, why do I have to pay your bills?
She's right. I was asked the same question. Let me sit down.
I really don't know about that.
So when you pass away, it depends on the contract, which we never read, right, with the creditor. So so the contract could say once you die, your debt doesn't survive. It probably says that. So maybe not. It just depends. It depends. Yeah. So I would you can call them and ask them. Something will happen to me, but I don't recommend paying it. I don't necessarily recommend paying it, especially in the case. Because see, look, anybody listening? This only comes up if you go through probate. This only comes up if you go through probate. So if you have to go through probate, whether you have a will or not, you got to go through probate. So if you got a will, you still got to go through probate. Your creditors can attach to your assets. They file a claim in probate. You got to wait. That's the reason why it takes so long through probate, because the law says you have to publish the probate case that somebody that died, and we're in probate. It's the case number. It has to be published. They have to publish it for 3 weeks straight, and to allow for 6 months to pass. It's 6 months in Illinois versus 3 in Indiana. 6 months have to pass before you can do anything with those assets, and that allows time for your creditors to file claims against your property. That's another reason why we don't want to get into that situation, because ain't nothing nobody can do. A judge can't do nothing but allow those claims to come in, and then you're fighting with the creditors, and settling this estate. What if you ain't got that much money in this estate? You got to give it all to them still. There are some cases where hardship exists, and trust me, I used to work I had a contract with the Office of Medicaid and Policy Planning for FSSA in Indiana, and part of my job, and I did it for a minute so I could learn what was going on, but before I couldn't stomach it anymore. But part of my job was to recover money on behalf of the Office of Medicaid and Policy Planning from those individuals who had received supplemental funds, right? Because they didn't have a lot of money, but they may have had a house. And so when they died, the Office of Medicaid and Policy Planning, because the property had to go through probate, because the family didn't know, the probate court automatically, every day, there was email notifications going over to the Office of Medicaid Policy Planning on who was dying. And they would check their database. Oh, that person got supplement. They go back like 7 years, and they want their money back. And if they have to force your family to sell their house to get part of their money back, they will. So I did that for a little bit. So, yes, ma'am, I'm sorry.
Okay, no, that's okay, this is an awkward question anyway. Is there a ballpark figure of what it would cost a person to set all this up?
Yeah, I mean, it's not awkward. That's what you want to know, right? How much it's going to cost me? So for a trust estates plan, depending on everything you have, about $2,500 to $3,000. And like what happens a lot of times, attorneys will take, like I do, I'll take monthly installments. You know what I mean? You know,
And then to set up the other sorts of things like the pour-over will?
that's all a part of a state plan. It's $2,500. So that's the trust, that's the healthcare power of attorney, the financial power of attorney, the pour of a will. That's all of that. And then that includes filing with the recorder's office. Like, you know, that's why I said $2,500 to $3,000 because it's the attorney's time, but then you may have 4 properties. You know, that's $98 a piece to file. That's $400, right? To record, just to record it in administrative costs. But you don't have court fees, you don't have publication fee, you don't have none of that. So $98, right? And then time, right? In an investment of the attorney's time and your time. And yeah, so that is a toady, which is separate, you know, 50, maybe you got an attorney you're talking to, may charge you like I said, $150 an hour. That's what I would charge just to, so a couple hundred, but then you're squared away, right? So you were thinking about, what's your name, Miss Lady? Diane and Miss? Right in front of you. Rita, Miss Rita. So you were talking about, I just wanted to close that out. You were talking about your daughter, and you were saying that she needs to pay your bills until she sells the house, but she may not have the power to sell it if it's not, you don't have something set up, like a toady, or like,
Well, I have a will and I have a trust, but I'm just trying to make.
Figure out what
sure
you-
everything is.
so is the property in the trust? You think so?
I have to check.
Can you call me? Can you call me and I'll check? I do want to, and I'll do it for nothing. I just want to check to make sure, because it sounds like you got something, but I don't see the need for a will and a trust. So I just want to make sure that it's not just a will and she don't have to go to probate, you know? Yeah, so. So you're gonna have to go through probate anyway. So let me ask you a question. Was your thought that of having a will, did you think you wouldn't have to go through probate? Both of you, both? Oh,
But the will is old,
yeah, so,
20, 30 years ago. I got an older sibling who died, and I thought, well, I should probably ask.
yeah, I just to consider the trust. And you can do a land trust, it just depends on what you have. So you're gonna go back and think about it. Miss Rita, what you were thinking?
Well, when my husband passed, we had a will.
Yeah.
And so when my husband passed, I just later on decided, because I just had a dependent daughter, I would set up a trust for her. I thought it would be easier if I set up a trust for her rather than just send the will.
Yeah, so that was the situation then, but see, things have changed. So we'll talk about it, because you said you have a dependent daughter. So that is another, the topic, right? You know, guardianship, possibility. I don't know if there's a disability there. So that's something separate. You know what I mean? That's something separate for sure. So helpful, you guys, is helpful? Okay. My number is at the back. You can call me. Thank you for coming and then getting the information. Yes, ma'am. You're welcome.
My husband, he just recently had passed last year.
Okay.
Both our names was on.
The D, I know it's emotional. I'm so sorry.
Thank you. I'm sorry for your loss also.
Thank you.
Yeah, I was about to leave.
I know. So I try not to do it anymore, but
I was gonna leave because I was getting emotional.
yeah, I know.
But so both our names was on the house. So when he passed, They took his name. What I never did through the survivor affidavit.
Who is they?
The mortgage people.
That's interesting, isn't it? See, these people doing all kind of shit to us. I'm telling
So
you.
they took his name also. Now the house is just in my name, but do I need to go down to the
I would search for it online, so you know it's in your name. How? Because you got a copy of the deed. What did you get a copy of?